Good morning and welcome everybody. Great to see so many people joining us for our webinar this morning. And we are here to talk about the hidden cost of data subject access requests. So if you are here to listen to anything else, you are in the wrong place. My name's Esther Carter. I'm a partner at Moore Smith and I'll be doing some light chairing for today's webinar. There's quite a lot of familiar names. I can't actually see you all, or that would be great on the attendee list. But for those of you who don't know us quite so well, Moore Smith is a leading audit, tax and advisory firm. We work with businesses across a whole range of different sectors, as well as not-for-profit organisations and private client. And we're also part of More Global, which is an international network with presence in over 100 different countries, so very well placed to help our clients with their international journeys. And we also have a risk advisory team within MKS, and that incorporates a data protection advisory team, and they provide advice and support to clients on data protection, cybersecurity, and AI governance. So data subject access requests, so they're not really just an occasional compliance task. Organisations really are seeing a clear rise in the volume and complexity, and that's being driven partly by AI generated requests and links to employee disputes. They're placing increasing pressure on HR, finance, operations and IT, and can consume significant amounts of time. They can also increase regulatory and reputational risk. So the new requirements under the Data Use and Access Act will also introduce mandatory internal complaints procedures, which is going to add further compliance requirements. So today we're going to step back. We're going to explore what's driving the shift and explore the often overlooked cost to organisations, and have sort of a bit of a think about what practical, effective DSAR processes look like to reduce disruption, risk and expense. So I'm delighted to be joined by Megan Misra and Rich Jackson. Megan Misra is a senior data protection officer in our cyber and data protection team at Moore Smith, and she has extensive experience in supporting organisations in sectors such as health, care, charities, across startups both in the UK and established companies as well, and international groups. And she spent 12 years at the Information Commissioner's Office and has since worked in central government, advising on data protection matters. She also holds a long string of qualifications with lots of letters in them, the CIPPE, CIPM, and she's a member of the IAPP and NADPO. So hopefully some of you know what all of that means. Rich Jackson is a data protection officer in our cyber and data protection team at Moore Smith as well, and he brings experience in cybersecurity, data protection, business analysis and project management. He's a regular speaker on cyber risk management and has a particular focus on the sort of the human factors behind social engineering. And he also regularly features on more ClearCom webinars and podcasts and has spoken at industry events, including Accountex. So before we begin, just a few housekeeping points. This webinar is for you, so please do ask questions. It makes it much more lively, much more interactive, and you're going to get more out of it. Please pop your questions into the Q&A function, not the chat. It's much easier to keep track of them in the Q&A function, and I will try to weave those questions in to our panelists as we go. And if we don't get through them all, we will answer them to you after the webinar. Today's session is being recorded, so please do share with any peers or colleagues who haven't been able to make it today. And finally, there will be a very short feedback survey at the end of the webinar, so I'm pretty pleased if you could fill that out. That would be super useful. So getting started, we've all got our cameras on, our microphones on. Good. So I think we're going to come to you first, Megan, to just, I guess, to tell us a little bit more about what data subject access requests are and why they're so important.
Sure, and morning. Yeah, so I'm going to refer to them as DSARs today, but you might hear them referred to as SARs, subject access request, data subject access request, subject access request, but I am going to call them DSARs this morning. It is considered to be a fundamental right in the legislation, and it is not a new right. It existed in the legislation prior to UK GDPR. You used to have to pay to make a subject or DSAR under the old regime. So that, although not a huge amount of money, but it used to limit the amount of requests that people would tend to make because you had to pay for it. It's free under the current legislation, unless it's manifestly unfounded or excessive. So individuals have numerous rights under the legislation. This is one of those rights, but it's the one we see mostly
Mm.
used by individuals. So it essentially enables individuals to request a copy of any personal data that an organisation is processing about them. And it's really there as a right to enable individuals to check inaccuracies, to check why that organisation might be processing their personal data and how they're processing it and how long they keep that information for. The Information Commissioner's Office, the ICO, the regulator, considers it a fundamental right as well, and they do take action in relation to
Mm.
SARs. They in their last annual report, they reported getting 42,000 data protection complaints in that particular year. So that was 2024-25. So that's a sharp increase. And recent changes to the legislation mean that organizations only now need to do reasonable and proportionate searches, but even that is still substantive in terms of responding to a SAR. And we'll talk about that in a bit more detail when we talk about complexity.
Thanks, Megan. And Rich, was sort of coming to you. What maybe sort of tell us a bit more about what is it that's sort of fundamentally changed in terms of sort of the volume and the complexity of DSARs?
Yeah, yeah. Morning, everybody. And that's exactly it. I think it's the volume and the scope and complexities of the DSARs which has shifted. So as an outsourcing team, we have a high number of clients, and Megan and I experienced from late 2024 and into the beginning of 2025 this sudden increase in clients asking for support with subject access, which our view, and that seems to be the view of the data protection community, is that that is linked quite closely to the use of AI in terms of the generation of the requests themselves, and potentially people and data subjects being more aware now because of maybe using tools like ChatGPT of how to actually submit a request. And the knock-on effect of that is that the request is far more detailed in its scope in terms of what people are actually asking for. And that generates into or manifests into a really legally worded document that our clients are receiving or organizations are receiving, as opposed to, please send me copies of all of my data, which, to be fair, Megan, I think carries just as much weight. It's just the scope that's changing, I think.
Yeah, and exactly as you said, it's the way it's worded. So you'll often get a bullet point list of everything someone wants, including the metadata of all the emails, the documents and all the rest of it. So you will get a very prescriptive list of everything that someone wants, which essentially accounts to everything that organization might be processing about them. And the world's moved on quickly. And even over the last sort of 5 years, organizations are holding so much data, in emails, in social messaging apps, WhatsApp, SharePoint, it's just, snowballed in terms of the amount of data that organizations hold, which then impacts on, trying to respond to requests when you receive them.
Mm.
Yeah.
And how far back can people request that data from?
So that's a really interesting question, because there's no limit in the UK or the EU GDPR, whereas in some jurisdictions we see a limit put on that. So, for example, in California, organizations only have to go back 12 months unless someone specifically requests something older than that. But here, in theory, you could have someone that's worked with you for 20 years, and you would have to go through 20 years worth of data to respond to a request, should they make a request. So there is no time limit, but just factoring in that it has to be a reasonable and proportionate search. So it's for organizations to determine what's reasonable and proportionate.
Yeah, I mean,
Mm.
as we talk more, I think about the reasons behind submitting a DSAR, I think that that also plays a part in the scope of what people are asking for. So, as Megan said, even though they can go back forever, quite typically someone might have a very specific objective relating to a certain time frame, and they will state that
Mm.
within the request, which does then limit the depth and the historical data that has to be reviewed.
Hmm. Somebody's asked a question. Are there key differences between DSARs and FOIs?
Yes. So FOIs request to public authorities. So you have to be a specific organization that's subject to freedom of information for a starting point. Data subject access requests are about the individual's personal data. FOIs can be about anything that an organization is processing, and it's unlikely you will get personal data back in response to an FOI request. So the DSAR is absolutely focused on the individual making the request. An FOI response will be far broader than that and unlikely to contain someone's personal data. So they're different regimes, different types of requests.
Yeah, thank you. And somebody else has asked about metadata. Do we have to provide this?
So often with data protection, you'll get the answer, it depends. And it will depend on what that is indicating about someone. But what we need to focus on is it has to be information about the individual making the request. So if it's not saying anything about that particular individual, then it is not their personal data. So you'd have to assess that on a case-by-case basis. I'm not aware of any examples where that type of data is being disclosed in response to a subject access request.
Thanks, Megan. And what about, I mean, maybe coming to you, Rich, so sort of, you know, we talked about AI making it easier for people to make the requests. How is that sort of affecting the responses to those requests?
So again, it widens and deepens the detail in terms of what's actually being asked for, and quite often these requests will be accompanied with suggested consequences if those demands are not met, which from on a very human level, as a recipient of a subject access request, as one of our clients, for example, that can cause a lot of emotional stress and pressure and concern. And I think it's just raising the stakes, I think, in terms of when an organization receives a DSAR, what they actually do with it from day one. So I think the use of AI is enabling people to access a right that maybe they might have been aware of in the past, but weren't quite sure how to go about getting their hands on their personal data. And there's a definite correlation between the access and easy use of AI and tools like ChatGPT, because as Megan said, this right has been around for a long time. And I think back in 2018, the data protection community was probably of the view that subject access requests would go through the roof quite quickly, and they maybe didn't, but that's what we're now seeing, I think, in the last couple of years.
Yeah, definitely.
And presumably AI is also helping people and companies respond to the requests as well.
Again, a really good point. And that's what we're seeing is a lot of software is now being developed with AI sitting behind it to enable organizations to effectively do the drawing together of all the information that might need to go out in a response, helping with the redactions. And so a lot of automated on the back of AI is being introduced and developed as we speak. So that's a quite fast moving field as well. Yeah.
Logistically, that's, I think, is the core challenge with the DSAR is actually accessing and collating and reviewing the data as opposed to maybe presenting it back or the redaction work. And so one of the challenges we have as a team, if we're supporting clients with a DSAR, is actually going through the sheer volume of duplication within the documents and emails or WhatsApp messages. So I think, that's AI is definitely playing its part. And as Megan said, there's a lot of software emerging that's supporting it and reducing the labor overhead, because that's a key factor in subject access.
Somebody's asked, how far do you need to go in order to redact third-party data?
Again, it's that common response in terms of data protection. It depends. You can take a really regimented approach and take out all other personal data, all third-party data, and only include the individual's personal data. That's the approach I tend to take if I'm helping organizations respond, but it will often be around the context of it. So it may be reasonable to include other people's personal data within the responses, but I would often make sure that those people are aware that that information is going out as well, because again, you've got no control over it once it's gone out.
And what about the speed? How quickly does a company need to respond to DSARs, both in terms of sort of acknowledging it and fulfilling the request?
Yeah, so essentially the clock starts ticking as soon as you receive it. So that's why it's so important to make sure your frontline staff are aware of when one is received into the organization. The timescales are that you have to respond within a month. So we would say that you should acknowledge that on the day that it comes in, you need to assess what the individual is asking for. There is provision to enable you to go back to ask them to clarify the request as well, and which is what I tend to advise organisations to do, particularly if someone's scope is so wide, because actually you want to drill down in terms of trying to give them what they're actually after, rather than sending them, 100 pages of emails that are irrelevant. So you can go back and clarify scope. You also need to do ID checks if you're not confident the individual is who they say they are, because you risk providing information that that potentially goes out to the wrong person. You can extend that 1 month timescale by an extra 2 months if the request is complex. For example, if you might need to get legal advice, if you've got swathes of data about that individual, it's all very much a case by case, but the bar is very high in terms of extending that time frame by an extra 2 months.
Yeah. Typically, I think we find that 1 month is achievable, particularly if the DSAR is identified straight away, and there's a system and a process within the organization that people can actually identify it for what it is. Where things tend to go wrong is maybe it takes a week or 10 days to actually even acknowledge the fact that one's been received, which makes a month an incredibly short period of time. So I think and I think we'll probably talk about that later, is just the importance of that process. And for everyone in the organization that is outward facing, whether that's email, telephone, or even on social media, that they can recognize the DSAR when it is submitted.
Questions coming in thick and fast. Somebody's asked about metadata. If it shows information about a third party having viewed a document which relates to the individual, is that metadata the individual's personal data?
Not necessarily in that context, no. So it's very much keeping it focused on information about the individual, not necessarily information about another individual who might have viewed that. But you may need to explain who has had access to the information depending on the context. So it's very much case by case. It's quite difficult to answer specific questions in the data protection world, because it is very much contextually driven.
And somebody's asked about, do you need to send the things that have already been sent to them, like emails that were originally sent to them or contracts that were originally sent to them? Do you need to still send that to them again as part of the request?
Yeah, we tend to just treat it in and of itself. So even sending back information that they've already sent. So for example, an email that they've sent into the organization will potentially come within scope of the SAR. It just keeps it very much within that framework without having to worry what they've had or not had previously.
Right, I'll do last organisation question before we go back to the others. So, redaction tools. Are you aware of any useful third-party redaction tools that people can use?
Yeah, I mean, there's numerous sort of generic ones that a lot of people will be aware of. I don't know if we can name and suggest actual tools that people can use.
Product agnostic. I mean,
product placement is allowed, I feel.
Okay. I mean,
sorry, go on, me.
Go on. No, go, Rich. Sorry.
I was just going to say, aside from the brand or the organization that's selling them, in terms of what a product offers, I think from our experience, redaction is a standard sort of tool within most, or if not all of them. The key challenge is whether that tool also helps with the duplication. Because that tends to be where the most of the overhead is from a perspective of cost and time. So if that tool that an organization might be looking at does actually help to dedupe and gets rid of these duplications, which occur, I think, Megan, fairly mostly in email threads that are repeated.
Yeah.
So I think that's the bit I think which causes the most time. So if you're looking at a tool and it doesn't offer that ability to identify duplicates, I think that would probably be one to maybe avoid.
Yeah, but there's some commonly used PDF sort of software that does have the functionality of doing redactions, but it's very much a manual process.
Yeah, it's about the business case, really. If there are organizations that have whole teams that do nothing but deal with subject access because of the nature of the organization, whether it's public authorities or maybe in the care sector or education, maybe. We have clients that have to date, touch wood, have not received a subject access request, but know that at some stage they will. So that it might be they haven't got a business case for software, so there may be other tools that they might be able to utilize.
Okay, so Obviously, this all sounds pretty onerous to the companies receiving the DSARs. Well, I mean, Rich, what is the sort of the true organisational cost of a DSAR?
I mean, as you can imagine, it's time. The key I find is the behavior from day one of the organization that receives it. If the communication is good and there's transparency throughout the process, that tends to keep the requester in a positive frame of mind. Where these SARs tend to maybe get out of control and expand over prolonged periods of time, as if there's maybe the timeline isn't met, but there's been no communication about it or no reasoning and ongoing transparency. But I mean, typically, as an average, our experience is that a subject access request probably consumes about 15 to 20 hours of time on average.
Yeah.
From a financial perspective, obviously that varies on the organization and who's actually doing the work. But I think it's an increased demand on teams such as HR and IT in particular for different reasons. HR has an experience probably unlike any other in terms of most requests we're seeing now tend to be related to a grievance of some kind. So that I think there are pockets of teams within organizations that experience the cost more than others. But 15 to 20 hours is probably what most organizations will be looking at for an average DSAR.
And it's the sensitivity of this as well, because it's often, as Rich said, it's often under the umbrella of a grievance, a disciplinary, or something that's gone wrong, because you don't often get happy people making DSARs. But it's the sensitive nature of some of the data that someone within the organization is going to have to compile and go through and all the rest of it. So, and particularly these are people you know and work with. So there can be an emotional impact as well in terms of having to go through some really quite horrible information at times and really sensitive stuff. So it's that impact in terms of time, it's the emotional impact, and it's the resourcing impact as well. So you've got multiple teams having to draw in terms of just complying with one request from an individual. So think of that duplicated. If you get 2 or 3 in a year, for example, that's going to have a substantial impact.
Somebody's asked, can you be punished for delaying processing a request, or do you just need to justify any delays?
Right. So there's 2 limbs to that. If you keep, and it links back to what Rich just said, if you keep the requester up to date, it is unlikely they're going to complain to the regulator. If you are going to extend that time limit from 1 month to the additional 2 months, you need to tell them that before the 1 month initial period expires. In terms of complaints to the ICO, the regulator, the Information Commissioner, as I mentioned, they had 42,000 complaints. So people will complain if they don't get it, if organisations don't get it right. That can be based on the time, so they haven't had a response within a month, or it can be more often than not that they haven't had all the information that they should have received or think they should have received. So it's an area where the ICO can fine, but it's also an area where the ICO can take enforcement action. So they can force you to respond to the SAR or provide information that you may not have disclosed. Or they can prosecute individuals. And there's a recent case where they've prosecuted a director for refusing to respond to a SAR from an individual. So a criminal conviction there as well as a fine.
Yeah, I mean, in many instances, within those 40,000 plus complaints, I think that the root of it is the person wasn't potentially entitled to receive some of the information they were expecting or hoping to receive, and the organisation has quite rightly not disclosed it, but that then still leads to a complaint because they're frustrated or upset they haven't received what they're after. So those complaints are made up of probably a mixture, I would say, Megan, of justifiable complaints and just frustration from the individual.
But even at that end of the process with the ICO then being involved with the complaint, that's another resource you need to be thinking about, because you need to respond to the ICO's questions, and that can be another time-consuming sort of review of that process. So that's the thing you would least want, is someone going to complain to the ICO.
Yeah. A sort of related question. If an ID isn't provided or delayed, does the clock sort of reset until the organisation has received that ID?
Correct, yes. So if you're not confident that the person is who they say they are, you do the ID check. The clock doesn't start until that ID check comes, you're satisfied that they are who they say they are, and then the clock starts again. So you've got this little stopwatch clicking in the background.
Like a chess
putting
game.
that pressure on. Yeah.
Another person has said you mentioned WhatsApp messages. So if an organization doesn't use work phones but uses WhatsApp on employees' personal devices, is the organization still considered the data controller?
Right, so this is a really interesting question. It's an area the ICO themselves have reported on in terms
Mm,
of the prolific use of WhatsApp across government. It's a very much a case by case. Organizations shouldn't be content with a lot of stuff going around on personal devices, particularly on WhatsApp, if we use that as an
yeah.
example. It's outside of your governance. I refer to it as off-grid processing because you've got no oversight of what's going on there. Saying that, it's very difficult to police because if someone makes a subject access request, you are relying on staff to hand over that data that might be on their personal device. So you need to have some rules and governance around how individuals are processing personal data on their devices if they're using their own devices.
That's unlikely, though, isn't it? That people are going to voluntarily hand over personal devices knowing that something they've said in a WhatsApp chat might be
Yeah,
used.
yeah. So it is unlikely someone would agree to do that. As I said, it's very difficult to police. I mean, how does an organization require you to do that? But I think the important thing is having the policies and procedures in place to stop individuals doing
Yeah.
that, or for individuals to be aware of the risks of talking about people on WhatsApp chats or sharing,
Mm.
confidential stuff. Action has been taken recently against an organization for using WhatsApp for sharing patient data in the context of a hospital. So it is a tool that needs to be used with caution, I would say, in terms of processing personal data on that.
Mm. And what about transcribed calls? Somebody's asked, is the organization legally required to provide the full transcription, just with redacted names, or can they just provide a summary of those calls?
Again, it's going to depend on what the call's about because the call may cover many different areas, not just about that individual. So, yeah, you would redact out anything that's not their personal
Mm.
data. That can be a challenge in terms of unpicking what is actually their personal data. But no, there's no requirement to provide, the all the notes from a meeting that may not cover that individual's personal data. So it's assessing and narrowing it right down and making sure you're only disclosing
Mm.
their personal data.
Yeah.
Yeah.
I think in a world where we tend to be, again, going back to AI, using tools for operational and commercial benefits, so recording Teams meetings and transcribing everything for logical purposes, that just then additionally adds to the overhead when subject access requests are submitted. And so I think
Mm.
that's always a key takeaway in anything related to data protection, I think is to have in mind that whatever you're collecting or keeping and processing is going to be within scope should an individual submit a DSAR. And that
Yeah.
all goes back to retention policies then, Megan, doesn't it, in terms of what you're keeping and why?
Absolutely, 100%. So the more data you keep, the more data you're going to have to go through, and then it's like trying to find a needle in a haystack. So having sensible retention periods in, consider automated deletion on your emails after a certain amount of time, so people aren't using emails accounts as inbox. I mean, as filing systems.
Mm.
So
Mm.
having some rules around that, it just helps to reduce that impact when you do get a request.
Yeah. And I guess, Megan, it really is kind of the IT and HR departments that are going to bear the brunt of the effort that needs to go in to deal with these requests.
Absolutely. And it's thinking about how do you approach it. So I've worked with organizations where the IT team will just do a wash across all systems and do keyword searches, for example. So Jane Smith, JS, that type of thing. And that pulls back gigabytes of data. Or you can take a more focused approach and look at the people most likely to hold information about that individual. So it might be their line manager, it might be HR, and just doing a more focused search and bringing back in that point about it has to be reasonable and proportionate. So thinking about what your search parameters are and how you're going to search for that data. But inevitably, yes, HR are absolutely in the center of this when it's to do with
Mm.
employees or ex-employees making these requests.
Mm. And what sorts of organisations are sort of most at risk here from a regulatory perspective?
Um,
I mean,
yeah,
sorry,
go
go on.
go, Rich.
I was going to say, yeah, interestingly, so the subject of particular sectors that may be more likely to receive them is always going to be an issue, and absolutely again, going back to what we're seeing in the data protection community on LinkedIn, etc., education is a sector that's hugely hit by subject access requests at the moment, and operationally, in many instances, just unable to keep up with demand, which then obviously takes them over the month deadline in many instances. So yeah, I think that's definitely a sector. Public authorities, we've seen instances where city or county councils have been reprimanded by the ICO because they've got backlogs of a couple of years or maybe 18 months. They simply don't have the resource to keep up, based on the fact that they're going to be the sort of sector that people submit DSARs into on a consistent basis. So I think sectors definitely. We seem to see it in charity non-profits fairly commonly as well, Megan. I think again, so every organisation is potentially going to receive subject access requests, but there are some sectors, I think, by the nature of what they do, they're going to be more likely to receive them.
Sorry, Megan, did you want to add to that one at all?
Yeah, I mean, I think Rich just really reflected on what I was going to say. So when I worked at the Commissioner's office, we saw public sector bodies really struggling to comply. They often had small teams having to deal with sometimes up to 300 SARs a month in some areas. And that's where we see the ICO taking action. So enforcement action requiring them to complete a certain amount of requests within a certain time frame. And that can potentially be contempt of court if you don't then comply with that. So we see that fairly frequently and routinely as public sector bodies getting hit with that, but we've seen political parties getting hit with enforcement notices for DSAR. So it's often down to, you know, what type of backlog of these organisations got, what processes do they have in place to deal with SARs, and there's a bit of leeway there. The ICO do understand the pressures that organisations are under, but you know, the law is the law, and you do have to comply with it.
You talked about processes there, Megan. I guess to either of you really, where do the sort of the DSAR processes typically break down? Where does it tend to sort of go wrong?
I mean, typically from day one, if they're going to go wrong, it starts badly and continues. And that's typically down to, I think, initially, as I mentioned before, whoever receives it maybe not recognizing the request for what it is, and then maybe not have the organization doesn't have a process in place that kicks in.
I think Richard's text gone a bit there.
Yeah, I was
So I'll finish up. Yeah, so it's as Rich said, it's exactly that. If you don't recognize the request on the day that it comes in, the clock's already ticking. So that's putting you right on the back foot straight away. And it's having staff properly trained in terms of recognizing it, because it can be buried in another, you know, in other correspondence. So they might be complaining about something, but then buried within that might be a request. So it's being able to identify that as well. Or they may ring up and make that request, because it can be a verbal request as well. So it's having staff properly trained to cater for those and recognizing them as soon as they hit the organization.
And what does good look like in DSAR handling?
So we've worked with many organisations that do take this seriously and recognise the risks of not getting it done properly. So good looks like properly trained staff that understand and recognise a request when it comes into the organisation. It's having maybe doing some practice runs to you know, to do a test run to see what would happen if someone made a request. How would we approach it? Who would we speak to? Who needs to be involved? Similar to what you would do if you were doing a breach practice run to make sure that you can handle a breach should that occur. So having clear roles, who's ultimately responsible for providing the response? Do you need external advice? Do you need legal advice? And it's mapping that out in processes, but it's also thinking about the redactions, and that's the point where I think some organisations struggle, and my concern is that organisations often disclose more information than they should to the requesters. So thinking about what you redact, how you redact it, because there's quite a lot of stuff there that can be redacted, ranging from confidentiality right up to, as we've spoken about, third-party personal data as well. So it's having that mindset of keeping it absolutely down to what you're required to do.
Yeah. Right, let's go back to the questions that have come in. So one of them is around what's the most likely outcome that a requester is looking for? Is it compensation? I suppose this is linked to what is the most common reason that someone makes a DSAR.
So there can be many different reasons that someone makes a SAR. They could be looking for particular conversations that might support a claim if they're going to an employment tribunal, for example, and we often see those. It could be something where colleagues have fallen out at work. So again, they're looking for a smoking gun, perhaps, if we can call it that. It will depend again on the context of why someone's making a request. It might be someone external who's just unhappy with the way that something's been handled or a decision's been made. We often see unsuccessful candidates for jobs making requests, trying to get notes, or applicants that haven't got on specific courses at universities making requests, as trying to find out, what the decision making was behind that. So it can be many different reasons, and individuals don't need to tell you what the reason is either.
And what someone's
Yeah.
asked, what's the likely consequence from the ICO on a first complaint for a company?
It will depend how serious it is. So it will depend on the type of organization, the type of information that someone's asking for, and what impact it might have on that individual not having that information. So it is very much context driven. If just in terms of if we can call it a normal SAR, normal organization, nothing hugely contentious, and it's the first complaint against you, it's unlikely that there would be action taken. You might get some advice given to you in terms of what to do in future, or they may assess and feel as though that the individual hasn't been provided with as much information as they should have got, and they may ask you to look at it again and reassess it. Factoring in that from June, so next month, organizations will be responsible for handling data protection complaints before individuals can go to the regulator. So that's quite a step change in terms of complaints handling.
Yeah, it's from June 19th, isn't it?
Yes. Yeah.
Someone's asked, can you suggest some key elements that you would expect to see in an internal DSAR complaints policy?
In terms of complaints handling, we would expect to see a point of contact there, so individuals who would be responsible for dealing with that. Most organizations will have some complaints function in place. So it's an add-on to that, but you'll need to ensure that the individual has an awareness and understanding of data protection, because it could be someone complaining about exemptions that were applied wrongly or something along those lines. It could be someone complaining about a breach. It could be any raft of issues that someone might complain about. So that individual should have knowledge themselves or access to that knowledge to get advice if need be.
And someone's asked, in practice, how often have you seen the ICO actually take forward a complaint?
A lot. I've just been looking at their most recent annual report. So on the 42,000 complaints that they received, there was quite a high proportion of that where they don't necessarily fine or take enforcement action, but they might provide advice and recommendations to the organisation. That's the most likely outcome, is that you'll get some recommendations on improving your practices. But if it then happens again, they would reflect on that. The fact that you've had advice and recommendations, and if you've not done anything about it, then they would look at that more firmly next time round.
Are there rules as to how the information is provided? So, for example, are screenshots acceptable?
The broad principle is that you provide the response in the same format or the same way that you've received it. So if someone emails you the request, you would send the request response back by email in a password protected document or something along those lines. I won't go into the depths of how we do it, but essentially we get all the documents that are going to be disclosed to the individual into as much as we can into one PDF document to send to the individual, but it will depend how much information there is. It could be several documents, but yeah, screenshots we would put into a Word document, for example, and just trying to keep it as simple as possible.
A couple of questions, both asking could you say a little bit more about the changes that are happening on June 19th?
Yeah, so that change is purely around complaints handling, and that the organization's controllers need to have in place a complaints handling process for individuals. So up until that date, if an individual is unhappy with a DSAR response, for example, you could just say, if you're unhappy, you can go and complain to the ICO and off you go. From June the 19th, you will have to deal with that yourself. So you will either need to just build that into a complaints process that you already have in place, or you will have to have a separate complaints handling process for that, for data protection complaints. That's the type of work we're doing with organizations now to prepare them for those changes as they come, because it can be quite tricky and time consuming dealing with unhappy requesters who are complaining on the back of having made a request.
And are there any contexts whereby a DSAR can be refused?
Yes, they can. So where they're manifestly unfounded. So for example, if someone says, I'm only making this DSAR because I just want to wind you up and, waste your resources and all the rest of it, I'll withdraw it if you give me £500, for example. We have seen examples of that. You could refuse that because it's manifestly unfounded. If it's excessive, you potentially could. So someone making repeat requests over and over again and really just sucking up all your resources in terms of dealing with those is another point where you can refuse. You could refuse if someone can't prove ID to say they are who they say they are. So there are some examples of where you can refuse a request, but I'd be very careful in terms of when you do that, because again, they're likely to complain about that.
Thanks, Megan. And then maybe sort of final bit of a sort of wrap-up question. We're getting in the witching hour. So it's coming to you, back to you, Rich. What are the sort of the priority actions that organizations should be taking?
So I think that particularly for organizations that maybe haven't received a DSAR yet, they should definitely adopt the mindset that they will. So they need to be ready for when that happens for the first time. So really, I think around sort of being really proactive about designing and considering what the DSAR process should look like and what it should encompass. We touched on retention periods. I think that's key. So I think if in the same way as with business continuity planning, that a process is worthless if it hasn't been tested and sort of considered in more depth. So looking at retention periods and thinking, what does it mean if a person wants to go back 10 years or 15 years? Do we need all of that personal data? And what does it mean if it suddenly that comes into scope of a request? So generally, retention periods definitely to be looking at. As Megan referred to, the off-grid tools. So definitely give some thought to what might staff be using that we're kind of conscious of, but turning a blind eye to, or maybe we're not comfortable with, but it's going on. I'm factoring in that is going to potentially be in scope of a DSAR. So definitely a policy and some awareness in that area. The complaints process, of course, we're only sort of, I guess, 6 weeks away from that being something that organizations will need. I'm definitely seeing subject access as a core business requirement and overhead, and that they're only going to increase. So I think that's fundamental, I think, is just to adopt that mindset that we have organizations and clients already that are seeing this increase, but there are those which maybe haven't seen that yet, but they're definitely something that's going to play a bigger part going forward. And to make sure on that basis that you can recognize them, that the team knows and is trained in what a subject access request looks like, and then that there's a really smooth process in place to address it.
Well, Megan, Rich, thank you very, very much. We have come to the witching hour, so I will wrap things up. There are a few questions that are left. We will come back to you individually on those. No question will be left unanswered. So thank you all very much for attending today. I certainly have learned lots about DSARs. My knowledge was very limited before this webinar, so I think everyone else on this session has also learned a lot as well. Obviously, Megan and Rich, I'm sure, will be happy for any of you to contact them to explore any concerns that you have. Please do fill out the feedback form. That should pop up for you all. Other than that, all enjoy the rest of your day. Thank you very much. Bye-bye.
Thanks, everyone.